It was really interesting how the Copyright Office decided to deal with these very difficult copyright issues. And basically what the Copyright Office said was, we've looked at all the case law surrounding when you're a licensee and when you're an owner of a piece of software, and we've looked at the cases about when the Section 117 adaptation rights applies and when it doesn't, and what we've decided is that the cases are unclear. We don't know. Yes, we're the Copyright Office, but we don't know, what the issue is here. So instead of resolving that problem, we are going to say that either it's we're going to say that we think that, to the extent that in some cases the 117 or fair use right applies, or it's not infringing, we think that this is going to be okay, and they just sort of like moved beyond that issue. So I just thought it was really interesting that they recognized and sort of acknowledged the fact that the cases that we have to grapple with every day in order to help determine what people's adaptation and fair use rights are just like all over the map. Nobody really knows what the answer is there. And that they nonetheless said, this isn't going to be infringing because you're just running your own applications on the phone. And so they issued the rule, and here's the language that they chose to use. This, I think, was just so unexpected and great for people who have iPhones and who want to jailbreak them and run their own applications. I think it's, what we believe at EFF is you bought it, you own it, it's your phone, you can do what you want with it. But the other thing that I think is so great about this is how this promotes innovation in that market for applications. So there's lots of independent app stores out there now that are starting up, and I also think that what we've seen in the smartphone platform is that really interesting applications get their foothold in the marketplace, having been on the jailbroken platform, like whether it's tethering or VoIP or something like that, and then once they are adopted by people and there's like a real market for it, there's pressure for it to be adopted by the App Store for the rest of us who haven't jailbroken our phones. So I think this is really, a great thing for, not just for, the kind of like, it's mine and I can hack it if I want to, but also for the marketplace for apps for those of us who are, like me, who haven't jailbroken their phone and don't know how, but want there to be a real wide variety of applications out there. I mostly think of tethering and VoIP and not the fart ones, but whatever you like, it's fine, because that's what capitalism's all about. I want to mention the other EFF exemption that we won. This, I think, is mind-blowing, really, because whoever thought they'd do anything good for people who want to make fair use of DVDs. We asked for an exemption for non-commercial videos, basically like mashup videos that people create from ripping DVDs and then put up on YouTube or other distribution sites. There were film professors who had basically blazed the way for this. So Pete DeSherney, a film professor in 2006, had asked for an exemption to allow professors to circumvent CSS on DVDs so they could take clips of DVDs and show them in their film class. And he presented evidence to the Copyright Office in 2006 that the alternative there was, let's say you were having a class about, surveillance in the movies. Instead of being able to rip the DVD and take little chunks of the films to show them to people, you would have to have like an array of DVD players all queued up and everything to play, one for each movie that you wanted to play the clip on in order for your class to go smoothly at all. And the Copyright Office was like, yeah, actually that does sound kind of bad. So that was sort of like an in, really, for them to understand that there are lots of fair use reasons, not just for film professors and for criticism and commentary and all of that stuff, but a lot of fair use reasons, documentary filmmaking and non-commercial mashup type of videos, why we should be able to circumvent CSS. So they issued this rule. I almost fell on the floor, but it's awesome. So for those of you, whether you're somebody who makes these or somebody who watches them, it's awesome. I want to talk a little bit about Alex Halderman's exemption that he asked for with the assistance of the clinic at the University of Colorado and Paul Ohm's students there. Alex had asked for, he has done a lot of research on TPMs that are on CDs and that sort of thing. He was the one who found the Sony rootkit, and he had done research on other TPMs as well, and asked that security researchers like himself be allowed to circumvent these measures in order to find out whether these access control measures compromise the security of computers more generally, and also to figure out whether there was in fact one of these types of backdoor TPMs on any particular sort of media. And this is basically the language that he had asked for. The works he asked for were video games, and then also more general literary works like sound and AV recordings. And he said, look, we actually can't do the research that we want to do because of this. And one of the things that the other side said was, well, hey, you have a security testing exemption. So what's the problem? Congress has already given you an exemption for security testing. So if you recollect back when I was talking about the security exemption, that is only for computers, testing on computers. And this isn't testing on computers, this is testing on DVDs and CD-ROMs and those sorts of things. So it doesn't apply. This is just the security testing exemption is too narrow. And then, of course, the argument there is, well, that's what Congress wanted. It didn't want anything broader, so don't give them the exemption, and the battle goes on. What the Copyright Office eventually recommended was that the exemption be granted for looking at TPMs that control video games, but not for the broader class of AV and musical works. And they rejected the full exemption because they said that Halderman had not made a factual record that there was going to be real harm in the next 3 years. So this is another weird thing about the rulemaking, is you've got to show that there's likely to be harm in the next 3 years, which is like what's going to happen based on just what happened before. And he in the evidence that he presented, that they were able to present, looked to secure ROM and the few things that were out there, but those were about video games and not about this broader work, so they said, well, you haven't shown it. I bring this up, I guess, I just want to point out, like, a lot of people ask me when I talk about the jailbreaking exemption, does this mean I can also jailbreak my iPad? And the answer to that is no, because iPad didn't exist when we asked for the exemption, so we didn't frame the class of works as being those that cover the iPad. We didn't know. And it's the same thing sort of here. You've got to look at what happened in the 3 years prior and then project what might happen in the next 3 years, and you just don't know. And if you try to be more broad and expansive about what might happen, then the Copyright Office rejects your exemption because you didn't have factual evidence in the record. This is the text of the exemption that the Copyright Office did issue for video games. So you can see the same kind of very cabined, narrow stuff that we talked about before. It's got to be used. That primarily is better than the solely in my exemption, but you can see that try to narrow it and keep it small. Okay, I'm going to take a few questions here, and then I know there may be more questions, and we'll be in room 111 across the way. But if people have questions, I'll repeat them. Yeah, right over here. What's good faith testing when it comes to security? There's by asking that question, he's not admitting he doesn't know. He wants to know what other people think. It's a great question. This idea that somehow some people have good faith and some people don't have good faith, and what do you look to? Is it like, people who have PhDs are somehow in good faith, but people who are independent and are self-taught somehow are not? Like, what is the atmospherics that go to good faith? And this is one of the things that is interesting as a not as a theoretical lawyer, but as an advocate in this field, is all the stuff that goes around it that helps you try to convince, a court or somebody that something's good faith, right? So I guess that's a long way of saying I don't know. 5 minutes? Okay. Yeah. Does full disclosure mean you're not good faith? The disclosure comes, if you look at the exemptions, some of the exemptions are conditioned, or exceptions are conditioned on you're using the information solely to help the owner. So if you make full disclosure and it's not solely to help the owner, then that could be, under the statute, something that removes from you the ability to claim the exemption. Not in every case, because each exemption is different, but you know, that it's an issue there. I don't think Congress meant to be taking a position in the full disclosure versus limited disclosure debate, but it's a factor. It's definitely a factor. And for those of you, if anybody's in the audience who's ever come to talk to me about disclosure issues, you know what I always say, which is that the disclosure is legitimate, but the way you do it is going to condition what's going to happen, just because it's, you know, how people feel about you, and that those sort of atmospherics, when you're operating in a legal regime that's kind of fuzzy, really matter. So, yes, here on the aisle.
With regard to used handsets, what constitutes used? If I make one phone call and
What's used when you talk about used handset? My answer to this question is the same as my answer to the last question. I don't know. I mean, I guess I know what's definitely used. I think that they just put it in there and figured, let TracFone and Virgin Mobile litigate it, you know? Yes, over there. Yeah, so if you put tethering software or some other unapproved app on your phone, can they turn off your network access? And the answer to that's yes, conditioned just on whatever your service contract is, right? Because the contract probably lets them do whatever they want, and then you have a cause against them for, you know, contract violation or something like that. I mean, they preserve for themselves as network operators all of those rights. But you know, there's some difference of interest between AT&T and Apple here. And I haven't heard of them doing that. What I have heard more, what we hear is that Apple will issue a software update that breaks the jailbreak, or, you know, as everybody's always afraid, will brick the phone. So that's the thing that we really worry about. And then there's all sorts of warranty issues where they could incur liability for intentionally doing something like that. Okay, I'm going to look over here on this side of the room. Any questions? Yes, this gentleman here in the front.
I was wondering on disclosure, could you like do click wrap TOS or something on your disclosure in order to limit the liability on disclosure and kind of fight fire on fire? Hopefully, just the same sort of limitations on usage.
So you're talking about when you do full disclosure, somehow issuing it with a click wrap license that says, I promise not to sue, I waive my right to sue, or something like that?
It says that you're going to use it in good faith for the intention of the end user.
Oh, I see. To condition the release of the information through a toss on saying that you're not going to use it for bad purposes, but for good, and then the security researcher can say, look, I didn't, you know, distribute it in a bad way because I had this toss on it. Do you have a thought about that? It's true, you know. If you do that, and then let me know so we can see if it works or not.
I don't think it can hurt.
Yeah. I mean, I don't know. I'd have to think about that. So usually, what I say with stuff like this is I say, you know, we can try to be crafty, but it doesn't always work as well as we would like. So I'm going to take this person here, and then I'll come to you and say, yeah. Can you say again?
Like phones put out by certain carriers that have a bunch of bloatware. For instance, your phone has Windows 6.1 running on it or something like that. Another version of Windows 6.1, the reason why you're doing it is what we call bloatware that carriers are on.
Yeah, if you're just deleting programs you don't want. And are you saying you have to circumvent some technological measure to delete the software off the phone? Huh. I got to think about that. I mean, the exemption certainly isn't about that particular thing. See, this is really good because, you know, the rulemaking is actually going to start up again in like about a year and a half or so, and we're going to ask for more. So, you know, if you can email me about this, I'd be very interested in thinking about it, and then also thinking about whether we want to ask for an exemption for it. Yeah, thanks. This gentleman over here.
I was curious if the EFF has any goals of trying to perhaps weaken what can be put in a toss. Because I understand that a lot of the tosses or the EULAs for software like Microsoft allows them to come into your physical space and invade your, you know, privacy to audit you. And I've always wondered, you know, where do they draw the line? Can someone make a toss that allows you to perpetrate a violent crime on a licensee? I mean, where do they draw the line?
Yeah. His question was about EFF's work on terms of service and other kind of adhesion contracts and limiting, you know, what's allowed in there. Do you want to take that, Matt? Okay, so we have a lot of stuff we do on this involving trying to say that you cannot waive reverse engineering rights or other kinds of fair use rights through these click-through agreements. We have our work we do on the computer crime area that Matt talked about involving saying that terms of service can't be enforced as a matter of criminal law, and we have a bunch of like sort of unconscionability type work we do on other terms of service issues. So the thing with terms of service is a question of, is it a contract? And that's like the first thing is about formation, and then the second part is about substance. The second attack is on substance and is